Howdy guys, Attorney Walter Hnot. We're going to get right into the video. First and foremost, Attorney Walter Hnot with Disability Resolution PA. Of course, if you're looking for a disability attorney, you could consider me or anybody else. But if you're looking for somebody with my style, then yeah, okay. Now, next thing, please remember, if these videos are helpful, please remember to like, subscribe, and leave 5-star reviews. I put them in the little chat section, and I will also put them in the comments later. Now, this video is of particular importance, and I want to spend some time on it. Sometimes I go through things quickly. Sometimes I like to slow it down. This is one of those times when I like to slow it down. Let me go into why. So here's the deal. There's 2 new rules that are super duper important when it comes to the Social Security Administration for essentially reaching into 2023. So as far as like new rules for 2023, these are very relevant because these are the only 2 rules that were released by the Social Security Administration as SSRs. SSRs are super important. What are they? Okay, Social Security rulings. I pulled up a little yada yada from the SSA website so I can read it to you. That way you feel comfy and you relax in your little comfy blanket of knowledge. Here we go. SSRs are a series of precedential, basically rules to be used in subsequent similar cases, okay, or decisions relating to the programs administered by the SSA and are published under the authority of the Commissioner of Social Security, right? So it's under the Commissioner Kijikazi. She blesses them and says, go forward, SSRs, and continue to be our standards and rules of operation, blah, blah, blah. Okay, cool. Now, SSRs may be based on case decisions made at all administrative levels of adjudication. Federal court decisions, commissioners' decisions, opinions of the Office of the General Counsel, and policy interpretations of the law and regulations. So think of these as like not ultimate definitive law passed by, Congress. Think of these more of like a step down from that. These are kind of more like agency laws, right? That's okay, cool. Agency laws. SSRs are published in the notices section of the Federal Register. For 2022, there's only 2 of them published, and these are those. Under the authority of the Commissioner of Social Security and are effective upon publication. Now, SSRs do not have the same force and effect as the law or regulations. However, they are binding on all components of the Social Security Administration in accordance with 20 CFR 402.35 subsection B, and are to be relied upon as precedents in adjudicating a claim. Okay, cool, awesome. Let's get right to this. In order to do this video, because it's going to be a more technical video to explain to you why it is so important to understand how they're looking at fraud, I want to take some time. So if you guys are cool, let's hang out and let's actually go through and define how fraud is being reviewed in the future, because this is a giant policy update from what they used to use. And because it's an update, they'll probably be using it more, having everything rolling in the right direction going into 2023 and throughout 2023 forward. This was originally released, just so you know, in the middle of the year, being May 17th, 2022. Now, technically, we're going to be going over 2 rules here. There's SSR 22-1P and 22-2P. But let's get to the easy stuff first, because this is incredibly important. And why is it important? It's simple. It's actually really easy. It's important because anything you do creates a statement, because everything's online. You on a jet ski on Facebook, a thing you say on Twitter, this or that or whatever, blah, blah, blah. Everything is a statement now. You drive to a bar when you're not supposed to be there because you're disabled. There's cameras everywhere. Everything is available, unlike how it used to be back in the day, which means that there's evidence to prove that you making a statement, right, could be making a fraudulent statement. Oh, I can't go out and have a good time. Well, why are you at that bar? Also, my apologies. I don't know why this shirt is so huge. I'm starting to think it's not even my shirt or how I got it. I'm not even sure. It might have come home in like a bag from like one of the homeless centers I work at, but this shirt is huge. Anyways, my apologies, guys. So back to the point. We're going to define essentially how the SSA deals with fraud going into 2023. Okay. Fraud, the definition. Fraud exists when a person with the intent to defraud, so it's a human being, not a dog, a human being, with the intent, you meant to do it, to defraud. We don't have to, you got that one. Either makes or causes to be made, right? So you're making it happen. A false statement, you're saying a lie, or misrepresentation, you're saying a fibble of a material fact. My apologies. So what's a material fact? A material fact is a fact that they use to decide whether or not you're disabled. That's what it is. Or whether or not you were earning money, while trying to get retirement and didn't claim it on taxes, blah, 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 whatever. Okay. I'll read it again up to that point. Sorry, I got distracted. Fraud exists when a person with the intent to defraud either makes or causes to be made a false statement or misrepresentation, a fibble, of a material fact for use in determining rights under the act. Okay. For use in determining rights under the act. So what this is, you're making a fraudulent statement or a fraudulent fibble, right? And it's within your mind that this will be used in determining rights under the act. Meaning, under their law, you're cooking up some bad books to deliver to them potentially in the future for benefits, supplemental security income, social security, disability insurance, widow's benefits. All right. Okay. So there's more to it. Or conceals. So think omission. We like actions and omissions in law. Think omission. Or conceals. You hit it. Or fails to disclose. You fibbled but didn't tell anybody. Nobody knew the fibble happened. A material fact, a fact that they use to adjudicate whether or not you were disabled or whatever, for use in determining rights under the act when trying to get on a program. Okay. All right. Now that's number one. You've got to know what fraud is. Number two, you have to know what similar fault is. Now, before I read what similar fault is, this is incredibly important. Similar fault is a made-up phrase, at least to me, and I did a little search. It's a made-up phrase by the SSA that does not sound like what it actually is. Similar fault sounds like you screwed up a little, they screwed up a little, we got all similar fault, but that's not what it is. Don't think that's what it is. It's not. I thought that's what it was when I first read it way back in the day. That's not what it is. So even though you're going to hear me say similar fault, I don't want you to think similar fault. I want you to think fraudulent statement, action, omission. That's what I want you to think. When you hear similar fault, I want you to think fraudulent statement, action, or omission, not the dumb phrase that they came up with. And now we will define it. Similar fault. I'm sure it comes from some old law, but similar fault is involved. And the idea behind it is that you have similar fault to fraud, right? That's the idea. Similar fault equals fraud. It's just a bad way of putting it. They could have labeled it any other way. All right. Anyways, similar fault is involved with respect to a determination if. Let me just define that, because that was the worst wording I've ever seen, ever written, ever evsies. Similar fault is involved when, let's just keep it at that. That's simple. An incorrect or incomplete statement. So an incorrect, when you make a lie, or an incorrect statement when you leave out all the bad parts and keep all the good parts. Oh, that's what it is. Okay. An incorrect or incomplete statement that is material. They used it to figure out if you were disabled. To the determination is knowingly made. You knew, you had intent, terrible person, right? That's what they're saying. You're a terrible person. Or information that is material to the determination is knowingly concealed. So what does that mean? What does that mean? It means that you fibbled and you hit it. Okay. All right. So now, with all that said, fraud and similar fault are very similar. I I think fraud is the idea of the creation of it, and similar fault is kind of the expectation of the use of it. So let me rephrase that. If I'm gonna create fraud, this is an error. Well, this is an errors can, right? And I'm hiding the rest. I'm creating an omission, and I try to sell this off as a fancy errors can that's worth 3 times as much. Then that would make me a bad person creating a fraudulent statement. But only when I transfer my communication to the potential buyer that I want to go ahead and sell that puppy as a not correct can, then we get what's called similar fault, right? Because we're starting to use it towards the purpose of that illegal thought or tendency, right? So the idea is one is the creation and one is the use. Okay, even though they don't really say that, they don't even get at that. That's the way I always looked at it, right? Fraud, similar fault. Okay. Now, I'll read you the quick material definition. Material describes a statement or information or an omission from a statement or information that could influence us in determining entitlement to benefits under Title II or eligibility for payments under Title 16 of the Act. All right. You hear Title II, you hear Title 16, think retirement. Oh, wow. Jason Reed, thank you so much for the $4 donation. Love the little hippo. Love it. Very cool. Love the blue color too. That's one of my favorite colors. Excellent. Thank you. That's awesome. So one of the things you got to know is that they go through in this and define what they're worried about. They define fraud. They define similar fault. They define material, knowingly, reason to believe. These are the things. Let me read you reason to believe. Reason to believe means reasonable grounds to suspect that fraud or similar fault was involved in the application or in the provision of evidence. The reason to believe standard, this is the important part because this defines the standard, requires more than mere suspicion. So it's more than suspicion, more than mere speculation, right? I will speculate, right? No, it's more than that. More than a mere hunch. Oh, I think it's Scooby-Doo. No, more than a hunch, right? But it does not require a preponderance of evidence. Now, let me go ahead and define for you preponderance so you know what it is. Because otherwise you're going to be like, where's the top part? All right. To prove an element by a preponderance of the evidence simply means to prove that something is more likely than not. In other words, in light of the evidence and the law, do you believe that each element of his or her claim/counterclaim is more likely true than not? That's a pretty high standard. And just to give you guys an idea here, there's, basically a hierarchy of evidence. And the hierarchy of evidence that we use in, criminal law or whatever basically goes and explains, essentially the very little evidence you could have, all the way up to the big stuff where that they murdered somebody. There's no way out of it. It is what it is. Okay. I'm looking up a picture of it, but it will take too much time to go through all these different types of evidence. So maybe we'll do another video on that. All right, now we need to get into what this thing is. Okay. The whole point of this is so that you understand how they think about erasing evidence that you have submitted. That's the whole point of this thing. So now we're going to switch over to this document 22-2P SSR, Social Security Ruling. All right. So here's what you need to know. Let's go over here. All right. If there's reason to believe that fraud or similar fault was involved in the individual's application for such benefits or payments, what they'll do is they'll go ahead and try to figure out whether or not that evidence should be kept in or erased or reduction of weight. So remember, you have bad evidence, right? There's potentially some fraud in there, right? Maybe it's not true. Maybe it's missing things. Maybe they, took out some words using Photoshop. There's a problem. So their options are to keep it, to go ahead and reduce the weight of the evidence. They don't think about it as much during their adjudication. They don't give it as much credit when they're weighing and balancing the worth of the evidence. Or they can get rid of it in total. Okay. I'll read you the specific thing that they put in there. We shall disregard any evidence if there is reason to believe that fraud or similar fault was involved in the providing of such evidence. Now, that's not a good quote because there's actually more options available to them than just that. Okay. Now, I want to read to you this because this is important. This is part of the policy interpretation here. Okay. A finding that there's reason to believe similar fault, fraud, was involved in providing evidence is sufficient to take the administrative actions described in this ruling. Cool. So they're going to do something. If they find out that something looks fraudulent, potentially is fraudulent, etc. Although a finding of fraud made as part of a criminal prosecution can serve as a basis for the administrative actions described below, such a finding is not required. So if you're sitting there wondering, well, how could they potentially find fraud on me? Wouldn't they have to have a criminal procedure to figure it out? No. And this is where it starts to get a little salty, if you will. A little bit like, that water doesn't taste right to me. Normally, right, in order for something to be considered fraudulent, you would expect a criminal court to be involved. You would expect a criminal court judge. You would expect, some sort of adjudication related to that field of law. But not here. No, sir. No, sir. No. They are going to use inside the SSA their own adjudicators. You got it. Yes. Who, don't do this stuff all the time. So, the outcome may be a little wobbly. All right, here we go. Let's keep going. We may discover suspected fraud or similar fraud related to a claim for benefits or payments or in the provision of evidence in a variety of ways. Now they're going to explain how they got you. Okay, this is important. This is a real rule. This is like the rule that's mostly going to be taking place and being rolled out in 2023. So this is important. Most often, we learn about fraud from our lovely office of Inspector General. I added lovely. I thought it was an appropriate addition. Okay. Also known as OIG. OIG, they're the attorneys on behalf of the commissioner. So, it's a lovely, friendly group. They dress up as Santa and other holiday stuff during Christmas. I'm kidding. No, they don't do that. They'll find you during the holidays. They'll find you. All right, here we go. So OIG is responsible. I'm kidding. OIG is responsible for investigating fraud in our programs and must notify us under Section 1129, subsection L of the Act, when it has reason, when OIG has reason, to believe that fraud was involved in an individual's claim for benefits or payments, including in the provision of evidence. Okay. So what they're saying is way number one that they expect to find out that you committed, an intentional fraud, whether you omitted something or you said something false, right? Is that they got tattletale group number one, OIG. That's their group. That's their, hey, that's like here's the line and we hold it. That's OIG. Okay. I heard a fellow, I'm not going to say that. I'm not going to go there. Now, with that said, we refer to this notification as a Section 1129L, which is their way of saying an 1129L when OIG reaches out to a DDS rep or an SSA rep, and they're like, hey, you got an L29L. I got an L29L. And then the SSA office is like, you got an L29L? They're like, yeah, we got an L29L. And they're like, well, what happened? Who was it? What happened? Who? Last four of their social, BNC code. And what happens is this. All that information, all that research swaps over. Now, at that point, you're more likely to see more CDI unit involvement. That's that group, the CDI units, that basically are hired on behalf of the SSA to go and investigate you. That's where the cars get involved that follow you around. That's where the cameras come out. That's where they make reports that are super boring to read, where it's like they give you timestamps and what the person did, and timestamp and what the person did, and timestamp what the person got a tattoo of, one by one by one. All right. We may also learn about fraud from a federal or state prosecutor during the course of a criminal investigation or prosecution. To me, that's where most of them should be coming from, but probably, maybe, I don't know. Maybe they are. Who knows? Okay. With regard to similar fraud, as we administer our programs, we may uncover information that provides a reason to believe similar fault was involved in the provisions of evidence in an individual's claim for benefits or payments. All right, so what they're saying here is they look at basically what's in your claim. Now, they also have machines that can scan all of your documents, convert your statements, whether typed or written, into a transcript, and then do a comparative analysis to see if you make statements that are inconsistent and how often you make inconsistent statements. That's one of the reasons I tell you guys, if you're going to hire an attorney to do your disability law stuff, don't hire them after you get your first denial. Because what happens is during that first period, when you initially file and you're filling out all those papers and you're like, oh, this one's about how I can do cooking and cleaning and laundry and getting dressed and handling hygienic, requirements of the day and going and shopping and doing my groceries and pulling my groceries and putting them away in my house. You guys always write down that you are Superman. And then I ask you, I'm like, all right, can you do this? Oh, yeah. Oh, my favorite one. I get this one all the time. Like, okay, so how far can you walk? Oh, I can walk 400 car lengths. Really? How far can you walk? I can walk 300 car lengths. Really? 300 car lengths. That's like 400 and something feet. Okay. That's like a football field plus 1/3 of a football field. Like, that's really far. We get that. So when you guys want to explain, can you cook? They're not asking you, can you cook? They're asking you, can you cook consistently without issue, to create these things? And if not, what are your limitations, right? So think about it. Can I cook? Yeah, sure, I can cook. Do you have any limitations with your cooking, right? Oh, maybe so. But what they're really getting at is, are you limited? If you try now, can you do it later in the day? Or are you exhausted and can't lift anything more? If you go ahead and make this big meal, are you going to be able to clean up all the plates? Or can you just do the function of making the meal and not cleaning up after it? There's all these little things that you kind of miss. And then I got to deal with them because then they're federal statements for the rest of the time, as long as the earth lasts and the government lasts and the universe lasts. It's one of those things. All right. So now, with that said, okay, and this is important right here. So now we know, number one, they get it from OIG. Number two, they get it from federal and state prosecutors during the course of criminal investigation and prosecution. Now, what they don't put in here is that another way that they usually get information, number three, and I see this goes to number two when I outlined it. Number three are jealous people that don't like you. I don't know what their deal is. I don't know why they care so much. I don't know why they attack your benefits so much, but it's jealous people that don't like you. Oh, did you see Jimmy? He was setting those blocks up to make a retainer wall. Oh, did you see Carol? She was having a good time at the bar. A little good time. A real good time. Why was she on the bar dancing? I don't know, but I took a video of it and I sent it to the SSA. That's what you have to watch out for. You got to watch out for jealous people because they report it, the SSA receives it, and then they adjudicate it. And they start hiring people to look into you. And then it's a whole yada yada. So if I were disabled, I would not put anything online. I just wouldn't. I wouldn't put anything online. I just wouldn't. Do you really need people's attention that much to like something and say, well, cool? No, you don't need any of that. I wouldn't put anything online. Look, if you want to go full Monty and like have a YouTube channel and like make 7 to 10 videos every week and do all the editing and push, and you want to make enough money to go ahead and not be on disability benefits, that's a rodeo because you know what I mean? You're going to run into this and then they're going to try and take away your benefits because you're reaching SGA. So you got to watch out. But if you're like most people are like, I'm disabled, I can't do stuff, I can't make a lot of videos, it is what it is, then don't post a bunch of stuff online. All right, let's keep rolling. We may find there is reason to believe similar fault was involved in providing evidence based on the actions of any individual whose actions affect the evidence provided in support of the claim, even when such an individual has no direct relationship to the claimant, beneficiary, or recipient, or acts without the claimant, beneficiary, recipient, or acts without the claimant, beneficiary, or recipient's knowledge or participation. These individuals may include, but are not limited to, claimants, beneficiaries, auxiliaries, recipients, spouses, representatives, medical sources, translators, interpreters, and representative payees. Now, let me explain what they're getting at. What they're saying is, let's say you go to the doctor and you know the nurse, and the nurse changes the result of one of the tests, and then the doctor, relying on those notes in that test, because the nurse likes you, whatever, I don't, you have some connection to the nurse. She changes the machine output. The doctor then relies on that new machine output, the numbers, and then changes their report. And that report then goes to another doctor, and that doctor sees you for something that, is parallel, interacts with whatever. Okay. Then at that point, you have two doctors who have essentially fraudulent statements. They didn't know. They still don't know. They didn't know. The nurse did the bad thing, but then the doctors, 1 and 2, expanded upon it. And that would create what's considered this, similar fault evidence. Okay, fraudulent evidence. All right, cool. We must disregard evidence under Section 205U1B and 1631E7A2 of the Act due to similar fault if there is reason to believe, meaning reasonable grounds to suspect. That's their standard. That's their adjudication standard. Reasonable grounds to suspect. What standard do they use to figure out if the fraudulent evidence should be removed or reduced in weight? They used reasonable grounds to suspect that the person knew the evidence provided was false or incomplete, or that the information that was material to the determination was knowingly concealed. Now, you guys already know what all those words mean, so you're good there. A finding of similar fault, fraud, requires more than mere suspicion, speculation, or a hunch, but it does not require a preponderance of the evidence. Okay? Which, when you really look at it, it's a really broad definition. It's really broad. And that's one of the problems with law, is that we have to use words to create this like little grouping, where you have like hardly any evidence, suspicion, right? Or you have, and then your suspicion is reasonable, right? It wasn't reasonable, now it is reasonable. And you just keep going up the chain until like, he murdered him, right? Because of ABCD, you found the knife and the red hand and the camera footage shows it. And Aunt Nancy told you it happened that way, right? That's the big one. Okay. I'm having fun tonight. I mean, I'm having fun with law because it's boring. And all right, here we go. Now, in certain circumstances, we may disregard evidence provided by someone who has not committed fraud or similar fault, but whose evidence relies on other evidence involving fraud or similar fault. Remember the doctors relying on the nurse's report where she changed the output of the machine? For example, we may disregard parts of a medical source opinion which rely on evidence that we disregarded from another medical source. Okay, cool. Depending on the extent to which the medical source relied on the disregarded evidence, we may disregard some or all of the medical source opinion. So now we're starting to get into the gray wiggle room. What they're starting to do here is they're starting to say, look, we may not always erase it from the record. We may look at it and say, this evidence is valid, this is not. We'll keep this, we'll get rid of that. They won't just wipe the whole thing. Or they might look at it and say, well, we're going to keep that, but not give it as much weight. We're not going to squint at it twice and think about it heavily. That's basically what they're saying here. All right. Now, this is an important part we're coming up to, so I'm going to explain it in more detail. Before we disregard evidence pursuant to 205U1B and 1631 E7A2 of the Act at the hearings level, our administrative review process, we will consider the individual's objection to the disregarding of that evidence. So if they say to you, hey, you're committing fraud. If they say to you, hey, we caught you red-handed, right? They have to notify you and give you an opportunity to defend yourself before the administrative law judges with the SSA. Now, this may concern you that it's not going to a criminal court to have a traditional adjudication, but rather the SSA is just going to handle it. They're just going to handle it. They're not going to use it. They're just going to handle it themselves. After considering any objections, our adjudicators, so the SSA adjudicators, which could be a DDS rep, not even a real judge, will decide whether there's reason to believe that similar fault, the fraudulent statement, was involved in providing evidence in the individual's case. Okay. I'm going to basically go through this stuff, but I want to go down here. If after disregarding evidence, we determine an individual is not entitled to benefits or eligible for payments, an individual who is dissatisfied with their determination or decision may request an appeal. So you have the right to respond, they can deny you, and then you can appeal. Okay. In conjunction with such an appeal, an individual may object to our finding to disregard evidence under the Act. Okay. We will consider any appeal in accordance with our rules for administrative review. So what they're saying is you can object to them taking your evidence and throwing it over there and not using it. You can object to it. You can say, no, you're wrong. This is correct. Okay. Now, with that said, we've gone through basically what you need to know. And now at this point, I want to take a moment to explain what worries me about this. This is the part that I think is the most problematic with this whole situation. Consider, okay, so remember, we're talking about the adjudicators here at the SSA. Determine if there is a reason. So these are literally, this is the step-by-step. I'll read you the step-by-step that their adjudicators have to follow to see if fraudulent evidence exists. In making a determination or decision about whether there is similar fault, fraud, all adjudicators must. So like this is the most important part of the video because this is where I tell you the step-by-step that they have to follow. A, consider all evidence in the case record before determining whether specific evidence must be disregarded. So you got to do a totality of the circumstances review of the evidence. You got to look at all of it first and then begin to start parsing away what you believe is fraudulent evidence. Cool. Part 2. Determine if there is a reason to believe as defined in this ruling. So determine if there's a reason that similar fault, that fraud, was involved in the provision of evidence. That somewhere in there was a statement, omission of statements, something was funky. Adjudicators may make, now here's the whoopee part. Adjudicators may make reasonable inferences. How do you guys feel about that? Adjudicators may make reasonable inferences based on all of the information in the record, such as facts or case characteristics. They're profiling you. They're profiling you. Common to patterns of known or suspected fraudulent activity. All right, now here's where the whole thing, in my opinion, just turns into a mishmash of what does that really mean? How is that really applied? There's just too much opportunity for the judges here to play games. There's just way too much opportunity here. Let me read it to you again, and then I'll tell you why I'm a little frumpy about this one. I'm not super giddy happy. I'm a little bit WTF on this one. Adjudicators may make reasonable inferences. All right. I'm warming up to it. Their job is to make inferences based upon their skill and knowledge and what they've seen. I prefer they rely on facts and then bullet point them to their analysis. But all right, they're going to make inferences based on all the information in the record. I like that. They got to look at the whole thing. They can't just wing this thing and say, I only read this part and we're going with it. All right, I like that. Such as facts or case characteristics. Oh, we got doggies. We got doggies out there. Such as facts or case characteristics common to patterns of known or suspected fraudulent activity. So I guess my problem is, what does that even mean? I get the patterns of known. Like if somebody does this, it's known to equate to that. I get that. But what hurts me a little bit is this patterns of suspected fraudulent activity. I mean, look, you can wiggle out and whittle out anything to look like they made a fraudulent, anybody, you ever seen two arguing couples, right? And one of them says to the other, hey, why'd you do that? And the other one goes, right, where were you last night? Right, that kind of stuff. Automatically, suspected fraudulent activity that must be adjudicated. That's why I get a little funny about this. It's very open. It's way too open. All right, for us to disregard evidence, it is not necessary that the affected beneficiary or recipient had knowledge of or participated in the fraud or similar fault. Okay, So doesn't matter. It doesn't have to be the claimant who did the bad thing. It can be somebody else and they can still get rid of it. So it could be something completely beyond, your capacity. And if they say, hey, we had suspected fraudulent activity, we felt it was reasonable, we're removing that really incredibly important doctor's report of yours that says you're disabled and just going with the one that we like, that our doctor, that we sent you to and paid for as the SSA, we're just going to consider that evidence. And we're going to throw out this other one because we had patterns that we saw of suspected fraudulent activity because that other doctor felt you were disabled and that other doctor really was leaning your way and our doctor wasn't leaning your way. And, we kind of want to go with that doctor, right? You see where the problem is? All right. Let me spell it out a little bit more. Okay. Let me give you why I'm a little bit cranky about this. Yeah. The doggies are in the back. They're getting a treat right now. So let me show you why I'm a little cranky. I'm going to read this to you again, and I'm going to read the problem part so you can hear the exact statute language. Okay. Adjudicators may make reasonable inferences based on all the information in the record, such as facts or case characteristics common to patterns of known or suspected fraudulent activity. But at the same time, these adjudicators must have more than a mere suspicion, more than a mere speculation, more than a mere hunch, but it does not require preponderance of the evidence. So my thing is, if they've got to have more than a speculation, then at the same time, they say that they have to have patterns of suspected fraudulent activity. Well, where's the line, right? If they can't have just speculation, then are they saying, well, you've got to have a pattern of speculation? Because to me, speculation, if I were to define it, sounds exactly like patterns of known or suspected fraudulent activity. Because you're speculating. You're like, that looks like fraud to me. I've seen that. That's probably fraud. Right there. Boop. Right there. Boop. There. That's what that feels like to me. When I read that, I'm just like, wait a minute. The judges, our little adjudicators, our little boo-boos, right? These adjudicators, our little ALJs, they can't just merely decide that they're going to throw your evidence out on mere suspicion, speculation, or a hunch. But it does not require preponderance of the evidence. Here's what I'm getting at. Here's the way the SSA works. Every time a big lawsuit is filed, something that goes all the way up, okay? Every time something like that happens with the SSA, that I've been able to study it and look at it and look at the POMs, the procedural rules, the Social Security rulings, any procedural changes, they take the thing that was pro-claimant and they get rid of it, or they change it, or they make it impossible to be pro-claimant. Classic example, when attorneys argued to go ahead and basically have hearings, specifically that are closest to the claimant's location, right? When they had to go to the hearing back before COVID, there was a huge lawsuit, massive lawsuit. Well, you should make my clients go to the hearing office that's closest. Well, then we started to notice that the procedural rules started to disappear that basically showed that there should be preference towards the claimant's location. A lot of those rules have been taken out and they no longer exist. So what I'm saying here is it's a monster machine that eats the rules that favor the claimants. Or it's a machine that basically is very broad in its definition and their ability to apply things or look at things. I mean, let me give you an example. All right, so you have evidence, right? Or they have evidence. They have evidence from your Facebook account that shows you, okay, standing on the little staircase that you get up onto, right? The little lift thingy, right? The thing you step up onto to get up onto a horse. And that's all they have. All they have is a photo of you standing next to a horse, holding the reins maybe, and you're standing on this little, this little step stool. And that created let's use their terms, pattern of suspected fraudulent activity, because then they had another photo of you right? Walking the horse somewhere else. Well, in their minds, could that create the idea that you were doing horse-related activities? In their minds, does that mean that you were riding the horse because you were getting ready to get onto the horse? Because what other reason is that step for? Maybe you were just taking a photo. Maybe you were just going ahead and basically, trying to put something up that looks fun because you're miserably depressed all the time. So let me ask you this. If they think that evidence that supports that you couldn't do physical activities should be thrown out because they have those photos, right? Do you think that that evidence would fall into a mere suspicion, speculation, a hunch, or do you think it falls into reasonable inferences based on all the information in the record, such as facts or case characteristics common to patterns of known or suspected fraudulent activity? Well, to me, that looks like suspected fraudulent activity, right? To me, that looks like something that, realistically, maybe you were riding the horse, maybe not. We don't know. Let's look at the jeans. Are there any saddle wear, any brown from the saddle on the inside of your jeans? Are you wearing the thingies on the back of your shoes to go ahead, the little spurs? Like, what evidence is there? Or were you just standing there up on the thing holding the rope to look cool for a photo? Is that the pattern we needed to have this, a full pattern? Or is the pattern that you were around the horse, you were holding the reins of the horse, you were then on the mounting block? We'll just call it, I don't know what it's called, but we'll call it that, okay? The reason why I say this is that it's not clear enough. They need to better define specifically what their standard of evidence is, because we have legal definitions for this stuff and it's still super broad and it's just not acceptable. Now, why is this important? It's important because I know de facto, because they keep hiring on and creating more CDI units. And they keep hiring on more people to go ahead and do these investigations. And the computers are more automatically triggering investigations. And the computers are scanning information that they have to search through all the statements that you made, search through all the information that you have, and all the statements that your medical providers made to figure out whether or not you are still disabled or a fibber. And so what this comes down to is a situation of basically a problem where they're using a lot of machines to create this problem of suspected, not speculation, not a hunch, but rather a pattern of suspected fraudulent activity. How hard is it to make a pattern with a computer that can analyze everything on your reports and say, oh, inconsistency, oh, inconsistency, oh, inconsistency? It's not hard at all. It's not hard at all. This is a pattern and conduct of anti-claimant activity on behalf of the SSA. And the reason it's being created, the reason it's happening, is that the SSA is looking for more ways to catch the fibbers. And here's why this all comes down. If they remove the evidence that got you originally found disabled, then they can request an overpayment and file federal charges against you for fraud against a federal agency known as the Social Security Administration. They could kick you off benefits and put a big bill on your head. And then you'd live in the same world I do, just like student loans. Every month. Another thing they can do is they can wipe out evidence while you're trying to be found disabled. Could be your best evidence, could be a doctor that supports you, albeit finding doctors that support people anymore is very difficult. The insurance companies have made sure of that. How many doctors are willing to fill out RFC forms? Physician statements. Lots of them won't anymore. Why do you think that is? Because it's a pattern of conduct that consistently makes it harder to be found disabled by creating systems that deny or disenfranchise those applying for Social Security disability benefits. And that's a problem, guys. It's a problem. It's the wrong direction. We don't have consistent record of a lot of commissioners that were pro-claimant. We don't. A lot of phone calls I get, about half of them I get, between the people who are looking to file for disability benefits and those who are having a problem. Okay. Those who have already filed, that includes on that side. But the other side is those having a problem, they're all almost overpayments. They're saying, I did this. They're saying they found this evidence. They're saying blah, 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 blah. At what point do we start to acknowledge that they will be tracking everything that's posted online by scanning your photo, when they are tracking the food that you order at the grocery store and making decisions about your capacity to use them? Well, I see that you ordered and had delivered a gallon of milk. Yet you stated on the record that you did not have the capacity to lift a gallon of milk. So how could you be ordering and using a gallon of milk? You see where this is going? It's too much technology creating distrust in human beings. And I get that there's fibbers out there. Don't think I don't. I represented someone and had to pull back representation. Don't think I don't know about it. I know about it way better than most. I'm in the industry dealing literally with people who try to pull things over on me all the time. With that said, though, and I think this is important to realize, this is all going to lead to a lot of overpayment claims where the SSA kicks people off of benefits because they found, this pattern of suspected fraudulent activity. That was more than a hunch because they had computers search everything on you. It was more than, and we'll go back to the wording here. We'll go back to it here. It's more than a mere suspicion because their computers mapped everything out. More than a mere speculation because their computers told them on such and such day, on such and such time, line 1. On such and such day, on such and such time, line 2. That's the problem. They're going to be using computers to say you're not disabled instead of physicians, because the computers will replace the physicians, because the computers will be able to throw out physician evidence that they feel is not consistent, meaning that it likely supports you. They sometimes throw out evidence that, hurts their ability to deny you. But most of the time it's evidence it's used that basically helps your claim. They'll say it's fraudulent because, hey, something's not right. It doesn't match up. Final thought. And then we're going to go to the questions, but we're going to start another video for that. Final thought. So if you want to catch me at the next video, I think it's going to be called try to stump the disability attorney or to stump the attorney. Final thought. The difference between your physician statements about your limitations and their physician statements, although they would say that there's no bias, even though they're paying for them, and sometimes that's true, but I've seen it go the other way. The difference between your physician statements, right, that you pay to go see, and their physician statements that they pay to have you go see, these sometimes have very inconsistent conclusions. And all they need is 1 or 2 more doctors to go this way, right? You could have 2 CE appointments. You could have a doctor swing away from this and go towards this. And they've got a pattern. And when they've got a pattern, they could develop a case against this evidence that supports you. That's where I see this stuff going. Guys, I will answer questions in the next video. So within the next 10 minutes, hang out. Well, not here, but, we'll end the session and then catch me at specifically the next video. Please remember to like. Please remember to subscribe. And please remember, if you want me to continue to push forward, and I have to do an update on it, a class action potential lawsuit for COLA fraud, how they calculate COLA and how you guys don't get enough of a COLA increase each year. Please remember to sign that petition. I'll catch you guys a little bit later. Have a wonderful day, and we'll go from there. 10 minutes, I'll be back. All right, guys. Bye-bye, guys. Bye-bye.